Fritz, Commissioner Novick. My name is Ashlee Albies. I represent the AMA Coalition. I'm the lawyer that they wanted to call up here to respond. So initially, I do want to respond to your comments, Commissioner Fritz. From my perspective, I think that the court, Judge Simon, he found that the agreement is procedurally fair, adequate, and reasonable. But he sat through a day and a half of the fairness hearing from community members about their concerns about this agreement. And some of those concerns included concerns about access to the Department of Justice and the Department of Justice's response to the community. So I presume, or I have the sense that one of the concerns that Judge Simon is trying to address with the order that he issued is these community concerns, and having this agreement be fair, adequate, and reasonable both substantively and procedurally, and giving the community that came out in full force to testify about their concerns about this agreement, to give that community the sense that he's also monitoring this. He's going to make sure that it's being implemented. And yes, the Department of Justice is the ultimate arbitrator under the agreement to determine whether or not the city is in compliance, and they can bring the city into court. But the court clearly thought that that was not enough, and that there needed to be an annual hearing instead of these quarterly reports, or he might not hear, as he stated in court to the parties, that he might not hear anything for years, and wanted to make sure that this was proceeding adequately. And I think his response to the community concerns that were addressed in that fairness hearing was to adopt the order that we see. And I would like to raise the point that it was briefed in our briefing in the Department of Justice briefing that we don't think that this is ripe for appeal. And if it's not going to be appealed, if it's not ripe for appeal, then what happens is a writ of mandamus or prohibition according to the resolution that you're looking at here today. And the U.S. Supreme Court has described a writ of mandamus as a drastic and extraordinary remedy for really extraordinary cases. And I would posit that going to these annual hearings are not something that calls for this drastic and extraordinary remedy. If the city would like clarification on the language of the order, I would suggest that the proper way to deal with it is to ask the court for clarification. That can be done in a letter, in a motion, in a hearing with the court. And I'm sure that Judge Simon would be happy to answer those questions and provide additional clarification. I'm going to defer to Mr. Kramer. Thank you.